Why would you ever plead guilty if you weren't? This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. All right, so as far as I understand this, plea deals, you have either plea deals or going to trial. And you're going to accept a plea deal to get a lesser sentence, or you're going to risk going to trial to get no sentence or basically no consequences, or possibly the highest consequence. So far, is that just kind of broadly how it breaks down?
Right. The plea deal is generally where the parties land in the middle and nobody's thrilled with the result, but they can live with it. And so a lot goes into considering whether or not to take a plea deal.
All right. So what would be, the first thing you're going to think about when considering a plea deal?
Well, like for example, if you're charged with 3 offenses and offense 1 carries a 5-year penalty, offense 2 carries a 10-year penalty, and offense 3 carries a 20-year penalty. Now, in this situation, if you go to trial, you risk a lot of time in prison. And so when you have 3 charges, sometimes you can meet the prosecutor halfway or meet in the middle and come up with a plea deal. Now, that can sometimes be a creative arrangement.
Okay, so a creative arrangement when you've been charged with 3 crimes, what does that look like?
Well, say for instance, the prosecution has you dead to rights on the second charge, the charge that carries the penalty of 10 years. But, in a circumstance where maybe you're charged with an aggravated assault, a strangulation, and a sexual assault, in that order of, the ag assault having less consequences than the strangulation, and then finally the sexual assault. So when you're looking at, whether or not to take a plea deal, you have to look at the total circumstances. Now, if you are guilty of the strangulation and the evidence is overwhelming against you, and you look bad as it relates to that second count, you have to take into consideration, if the evidence is overwhelming to that one count, the jury might just say, hey, you're a bad person, and maybe the evidence isn't as overwhelming to the other 2 accounts, but the jury could just be mad at you and convict you of all 3. So in a situation like that, we need to weigh our options.
So, all right, so you're saying that of the 3 of these, they get increasing severity, but your client in this sort of fictional scenario here is not at all guilty of one of them? Is that what you're saying?
Or even 2 of them. The fact of the matter is, when you're charged with felonies and you did some things wrong but not everything wrong, you need to weigh, what can the state prove versus what are they willing to offer for a plea deal. So in this particular type of situation, if you can get the prosecutor to back away from the sexual assault and then maybe require that you plead guilty to the 2 smaller felonies, but they're willing to recommend, minimal jail time or no prison time, then even though, say, you're guilty of the strangulation, but you did not commit the ag assault, that is, you're accused of pointing a gun at the victim, and you did have sex with the victim, but it was consensual, say you're in a dating relationship, but, she's accused you of having sex with her without her consent, you really have to consider if, you plead guilty to the 2 lesser felonies and you only committed the 1, but the prosecutor is willing to give you no jail time, and it keeps you from being convicted of that sexual assault, you may end up considering pleading guilty to both of those felonies, even though you're adamant you did not point the gun at her. Now, it happens all the time where, we sometimes have to artfully plead guilty in this type of situation.
I see. So then your client in this situation would say, okay, I'm willing to plead guilty to something I did not do in order to avoid the possibility that I'll get convicted of a much worse crime. So it's a little counterintuitive, but you say this happens all the time?
Yes, it happens all the time. And, you have to conduct your change of plea with your client artfully. There's an art to it. It's not necessarily just a science. So, in this type of situation, knowing that the evidence is pretty damning against you and a jury might not like you, and you say you didn't point the gun at her, but you did have a gun in the same room with you, sometimes it's just a matter of asking your client, if under these circumstances, you've read the charges against you, and under these circumstances, you are conceding that a reasonable jury could find you guilty of the aggravated assault and the strangulation, and they say yes. And, that is not misrepresenting what happened, and you are pleading to something you didn't do, but you're getting the benefit of the plea deal. That is, you're weighing the risk of going to trial versus the benefits of the plea deal.
Wow. But there are some instances where you will go to trial, right?
Absolutely. There's, unfortunately, the cases that we see most often go to trial are the sexual assault cases. And, they really are generally two people in the room where one says, I didn't consent or I couldn't consent, and the other one saying there was consent. And, it's a terrible position to be in if you're accused of that and you're saying there was consent. The prosecutor kind of has their hands tied in most of these cases because the victim is, wanting the maximum penalty and your client's saying, I didn't do it. And, you need to figure out, okay, if you plead guilty, not only do you have this conviction, which, severely affects your reputation in the community, you have to register as a sex offender, and generally there's jail time that goes along with it. You have to weigh that against going to trial and finding those 12 jurors that will listen to you and not assume you're guilty just because you're the guy sitting in the defendant's chair and you're accused of a really bad thing. And, hope that in going to trial, everything falls in place and you're able to prove your innocence even though it's not your job. It's the state's job to prove your guilt.
That does sound like a complicated proposition to work out what's the best way to go. So that's where great legal advice from a spectacular criminal defense attorney can really come in handy. So how might they get in touch with you for that?
Sure, we'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.